we will be guided by the directions of the court.
Okay. Counsel, do you have anything to say?
My Lord, in response to the statement as stated by the counsel to the fourth defendant, my Lord, without moving our application, but my Lord, we have in paragraph 4 of our counter affidavit, we actually attached the proof of service of our motion on the fourth defendant to show that they were actually served and they failed to file in response to that application. Yes, my Lord. And also, my Lord, we've also stated and shown evidence and documentary evidence to show that these vessels, the first and second defendants, were actually sold by the fourth defendant. And the proceeds of sale is in their custody. The claimants are claimants that worked on board the vessel before the fourth defendant took the vessels as receivers. Yes, my Lord.
It has not started. Okay. Okay. So what I'm really saying is this. In a case where we have the first to how many claimants?
Third.
7 defendants.
Third. First to third.
Third.
Yes, we are the fourth.
No, I mean the claimants are 7 in number. You are the third. Are you not? You are the okay. I'm not talking of defendants. I mean a case that has 7 claimants and 4 defendants are in the court. Now, those who have outstanding motions that are just housekeeping applications have moved them and the applications have been granted. Then it would appear you want to start off this matter immediately. So what I just wanted you to let me know is whether in a matter where there are like 11 people contending for something, even though some are contending for the same thing, can we start hearing it with only the 2 of you, one from one side and yes?
Okay, my Lord, my appearance is for all the claimants.
Oh, okay.
Yes,
You have...
my Lord. And for the claimants, the first to 7th claimants.
I see.
And our processes have been served on the first to third
defendants.
Yes,
let me put it
without any appearance or any court processes. Yes, my Lord. So, my Lord, I'm actually sorry that the claimants are not in court. They are seamen. But on the next agenda, at least they will have a representative in court.
Well, if they have something reasonable to do, why leave it to come?
I'm most grateful.
Okay. Is that why Mr. Kohn wants to move? What do you want to move?
My Lord, we have a motion of notice.
Okay.
Dated the 3rd day of July 2025.
3rd?
Yes, my Lord.
Okay.
3rd July.
It came before your memo of appearance? Okay. Extending the time which the 4th defendants may enter conditional appearance. Thank you. Well, since you're here. Your prayers in your motion or notice is just extension of the time within which you can enter appearance.
No, we moved that application.
and it was granted.
Yes, it was granted.
So,
This motion is like a preliminary objection as it were. We are seeking the order of the court striking out or dismissing the suit against the applicant, that is the fourth defendant, for want of jurisdiction.
okay.
My lord, that application was filed on the same.
That's what I see. All of them were filed on the same date. Striking out or dismissing the suit, or for such further order or others. Is that what we're going to hear? Okay. Please confirm that you've been served. Okay.
I'm saying it's because on 24th day of October 2020.
Okay.
That's okay.
Yes. All right. Mary, plain sheets, please. Yes.
Very well, my lord. My lord, our application is brought on 3 grounds, which is stated on the face of the motion paper and supported by.
Hold on. Just hold on a bit. This one. Okay. Brought. Your application is brought.
Yes, my lord.
Yes.
Pursuant to Order 17, Rule 1, Sub 1, Order 18, Rule 2, Sub 2, and Order 30, Rule 18, Sub 1 of the National Industrial Court Civil Procedure Rules 2017, and under the inherent jurisdiction of this Honorable Court, We are praying the court for an order striking out or dismissing the suit against the applicant. That is the fourth defendant for want of jurisdiction. In support of the application is a 17-paragraph affidavit deposed to by one Ayodeji Ate. Ate is A-T-T-E.
Yes. Yes.
My Lord, we also have
I didn't hear you.
attached to the affidavit.
Yes.
My Lord, in compliance with the rules of court, we also filed a written address.
Yes.
And we adopt same. And also the averments, all the averments contained in their supporting affidavit. As an argument in this case. And we respectfully urge your lordship to grant the relief sought herein. If my Lord would allow me to just make a few points by way of
Adumbration, the court will not allow you because we are eating into the time of the group that have there's a virtual hearing, Zoom. It starts by 12. We've taken 20 minutes of that time. And counsel, whatever you are going to adumbrate is in your written address. There is nothing else you are going to, they are all there. You people, you are so thorough when you are writing. Then after writing it, you want to adumbrate. No. I said no. We do.
Just to guide the court when considering the application. Because earlier on, the counsel or learned counsel, my learned friend, had made some statements which I didn't quite agree. And the first is that we were the receivers. He said that we were the official receivers of the first and second defendant. My Lord, as we've read the Amazon Act gives the fourth defendant upon acquiring an eligible bank asset, which is loans that debtors have defaulted to pay, to appoint itself as a receiver over the assets that were used to secure those facilities, in this case, these two vessels, and also to appoint themselves as managers of the debtor company itself. Those are two distinct roles under the AMCON Act, which we have stated here. In this particular case, my Lord, and as will be shown in the exhibit attached to our application, the fourth defendant only appointed itself as receiver over the assets of the third defendant, Pullman. That is the first and second defendant vessels, which means that the fourth defendant at no point took over responsibility for the management of the third defendant's company, which is the party that engaged the claimants to work on the vessels. It didn't assume responsibility for the management. So we can now not now settle the thing, pay the secret, who will try the company, because we didn't as the management of the thing. That's all. And on second point, when management was because we now other join us another country and don't we will stay with that very high in cycle it's not if my hearing any condition they are talking of right and it's not matter whether the party has failed the party to fail. Respecting then this country and on if the rules of time also look at it when
Okay. Thank you for that adumbration, but you can. You want to do what again? Okay. Yes.
Motion on notice. The claimants
Yes.
the claimants filed a counter affidavit of 8 paragraphs and is dated 24th day of October 2025.
On what date?
24th of October 2025, 2-4, my lord.
Yes.
And my lord, we have exhibit 8, we attached 8 exhibits. Exhibit A to A7.
Yes.
While the counter affidavit is deposed to by the first claimant. We rely on all the averments in the said counter affidavit, my lord.
Yes.
And in compliance with the rules of court, my lord, we filed a written address of the same date, 24th of October 2025.
Yes.
My lord, we adopt our written address as our oral submission in respect to our counter affidavit.
Yes.
My lord, we urge this honorable court to dismiss the 4th defendant's application with substantial costs.
Okay.
That will be all, my lord. There will be no need to add bring due to the
Okay.
court earlier. Yes, ma'am. I'm most grateful.
Yes. Give me a date. Ruling. Are they cancelled for the virtual hearing here? You're here already? Okay. Seventh of May. How do you stand on the 7th of May? How about you? So the case is adjourned to the 7th day of May 2026 for ruling. Yes. Okay. The next one. Thank you very much. Thank you. Oh, thank you. Thank you for coming. So you can go. Yes. I hope this thing will just by itself. No, it's not good. You see now, I've overused that phone, though not for this thing.
Maybe if you are using it, because less.
Yeah, I'm seeing myself. I'm unmuted. Okay. So, are you hearing me? Who's okay? Let's put up this one. Okay. Have you seen your client? Whose client is coming on? Does he know that we are doing this today?
Yes, yes. Okay.
Have you seen? Hmm?
When she speaks.
Eh?
When she speaks, it will come.
Okay. All right, let's start. Let's start. Maybe he will come on.
Champlain.
Okay.
Can you see her?
Yes, I've seen her. I've seen her. Yeah. Okay. All right. All of the matter.
Yes, number. Join.
Yeah, put on. Eshe Joy. Lemon accent. By who?
Okay. Okay, that's practice artist.
Okay, okay. Appearances.
Yes, she concluded her evidence, but we are doing it was exam. You have not.
Okay. Okay.
No,
Oh no. No, usually we have 40 minutes maximum to cross the line.
They are complicating our super. Listen of this, wasting the time. You have the right to achieve completions and how do we move forward? I know we got adjourned for today. For continuation. So him saying that they have 40 million, but it's supposed to be at the pinnacle of the court. The answer. Of course. That's what I don't going back to practice. I don't know why we making assumption where no basis. The business of this will continue from Mozambique. We are ready. That will be the property. They are not ready. They are not ready. Other than I don't much of why out and soon answer solution.
Okay. On the agenda, it was for cross examination because on the 24th day of June 2025, the court had adjourned the matter to the 1st of July and 4th of November for cross examination of BW1. So the next one we had was 1st July. The BW1 was called and was cross-examined. But I don't think the cross-examination was over by okay, that's 1st of July. The problem with this case is that it has suffered a lot of adjournments. So he used up the 40 minutes.
I don't know what the answer is. Try to he mentioned context. Was it the last time? Informed and very commission that even if I don't access to the time by the other person, but my love was I don't mention that if I step out to see the first we're not one dragging this matter. Leave the this piece because that one is mistake. Anybody. So if I not as person
Okay, what we shall do is maybe we shall hear her in chief. We will suspend the cross-examination. We hear this one in chief. Then we go through our records again. If that other lady has not been cross-examined, we invite her to conclude her cross-examination. But let this lady not travel from wherever to where she is and then go back. It will not be fair. Yes. Yes. So you are ready to take her in. Okay. You shall. She will now be W2. That's well, if there is such time, if time is not limit, we can take it together. So the court shall take the witness on the screen. We shall take her in chief because of the location she came from. If hereafter the court discovers that the PW1 had not been cross-examined fully, then cross-examination, then the next date shall be for the cross-examination of both DW1 and DW2. So we'll take her, then we'll go back and check. Yes. That is really good. So that's okay. What's her name? Maybe she's muted. She's muted.
Good afternoon, my lord.
Okay, you can now hear us.
I can hear you clearly, my lord, but I can't hear the other persons in the courtroom.
Okay.
It's
So
faint, but I can hear the judge very clearly.
okay. So please tell us your name.
My name is Bola Dale Akin-Kolapo.
Okay. We are about to take you your evidence in chief. So before we do that, we usually swear. You shall swear. So are you a Christian, Muslim, or pagan?
I am a Christian, my lord.
Okay. Would you want to swear or to affirm or not to swear at all? Would you want to swear or affirm or to say that?
Okay, I affirm.
Okay. So lift your right hand and say after me. I,
Bola Dale Akin-Kolapo,
yes, affirm
affirm
that the evidence that I gave in this case
that the evidence that I'll give in this case
before this court
before this court
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Okay. I think it's ready here. Yes.
Can you come closer to the mic, please?
Yes, can you hear me now?
Now it's better. Thank you.
I said, once again, tell this honorable court your name.
My name is Bola Dale Akin-Kolapo.
Tell this honorable court what you do for a occupation.
I currently serve as the country director for Girl Effect in Nigeria.
I serve a country director for
Girl Effect, Nigeria.
Why do you reside? Your place of residence. Can you hear me?
Now I can.
I said, please tell this honorable court where you reside.
I am currently at number 1, Wimborough Close, SE28 8HX.
She has to.
Please take it easy. My lord is recording for us.
Oh, okay. Number 1,
Yes.
Wimborough, spelled WHIMBREL, Close, London.
Yes.
Do you recall reporting to a written position before this honorable court on the 23rd day of March 2022? Do you remember?
Yes, I do.
Please, if you system, will you be able to recognize it?
Yes, if I'm shown.
On what day?
23rd day of March.
Okay.
Kindly confirm to my lord the copy that was scanned. That's your.
Yes. 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 Uh-uh. Have you resolved? Ah. 20. Is that because it's 20? Is that it? 20? 7th of then other day in March. It must be the belly must have done a very poor job because the only one that is in our file is 7th of March. Now it's 20 something, and this is 23rd. Okay, that's 7th of March. Let me see. Let me see the first paragraph. If ever I will say. It's not. No, no. Mm. Twenty. The one is 23rd. No. What show?
Motion for
Do you think maybe there's
on different
courts?
courts. I'm want to get if we file it separately or she files it alongside another process.
Okay. What did she say?
That's counter. She has not responded.
Is it
This time, yeah. So no five with
what what is Shay?
you register him and then else after. We don't have channel after. It's the same thing, it's the same, you understand? It's not NIC. Yeah, but you don't have it. Some they file there and send to us. Yes, yes. So
Hmm. Think that's just to do.
yes. For this one, yeah. That particular one.
Hmm.
Sorry,
No. So
as it is,
there's no other
thing we can do than to
take
take another bit.
because we've seen other
matters.
matters signed here.
I mean,
I mean,
filed,
filed,
they filed them and we see
they
everything.
filed them and we see
But that one
everything
is,
about it. But that's what even the stamping,
they are
they are
not
not.
the same.
So
So we
we
can check them.
if
If possible,
go
one
on
to look at.
it will work hardship to all of us if we use different documents for the same case. So give us the date, please. Are you in agreement that we find another date? It's not truncated as such because we are all here. The court, you needed, were you here? The court was so cool. The court really sent out everybody and allowed this case to be heard.
At least, I mean, this, that's how we like with the people. But none of this, we are taking, and then, I think, do expect that I don't think they because they also follow up whatever you find. I had that they file from Abuja. At least, I don't know how that's done. When you file from one, whereas their family is I don't know why. But I'm not saying it's not possible, but it's we are not safe. It's not we are possible. We are not safe. Whatever thing we are, we want.
And the court file, the one of the third, not here. Is yes, the one of 7th and 21st. So somebody did a bad job.
I cannot say it's a bad day because I have another matter before to fight.
Of the federal high.
So this matter I did not go for them. In fact, the council of letters I met in the top line that I wanted 400,000. It is because of this. I don't although I like that, but the did not have some time. You are 200,000. If they are seeking adjournment, based on what I will because it's very, very fundamental. But then whenever you cannot find the process, that will follow it. They said they filed this process started 2022. But we are not saying they're supposed to follow on the belief whether on the or on the part on the other part. This is their soul. The method of their process. They are fused with this.
Because you in the federal high court. Because you you are going to pay some costs at the federal high court.
I never, I saw the lawyer called you. And there's no correlation. I'm not surprised. And we did some, I took some of my, I will go back to conclude because the original articles to examine my on the next adjournment decided. I'm surprised that the cancer will be taken last week. And it's not even true that I at least the first time I'm hearing that you write a letter to the and you say I was caused against you. You have to prove that, and there's no correlation between whatever matter you just
Excuse me. Hey, we are taking a lot of time. So please let us know the dates. So I should become a robot. I should stop at the point that you started. I will write when it's time to ask you if I will ask you. I will do that. What
What
date?
date?
I
I
just
just
stand
stand
on
on
it.
it.
So
So
now,
now,
this
whom
whom do
do
I?
I, this particular case, how do we find who said? Mm, 2022. Yes. This one is been focused. You said? Or when we come on the next agenda to be for let's just say continuation of hearing. Please. The man.
He came in and he was saying that he doesn't want to say that the registrar claimant council has compromised. That's why we did not give the for adoption of that case. It's true, last year.
In this case.
Anyway, another matter. I voted for his population. I told him that there are people like him. I don't like talking to them. So it's matter for 2020. I still pending for adoption. Maybe we want 2025.
Those are the people who write.
I'm not saying no, that people will not talk nonsense. Then you don't know what is happening. So that's one of his bad days. I tried. Don't give him social. Let him be. Make 5 for. I don't know if they said make 5 is for events, but make 5 is most convenient for him. Because
What
they are
of
the last.
What's his name? Mr. Ami. It's not convenient.
It's of May. 5th of May. It's 5th. Let's not.
How about you? So 5/5/26. Eh? I said 5/5/26. So this matter is adjourned to the 5th day of May 2026 for continuation of hearing. Because before then we must have found out what is happening. And then we start from there. Council. About these costs. The court is going to go through the case file and see what is happening. But can we really say the business of the day has been truncated?
Some questions now which you can ask. And the position that is
Before we do that, whether the gender or self, and it's fighting another issue. But since 2020,
I think that is what they will discover more after court has risen.
on the issue, I'm thinking of I supposed to be right. I can follow the particular of the case before my work. Here, begin settler.
Yeah.
But unfortunately, looking at this matter and very much, I noticed that this picture is because it was priced in 2021, and it has been so far a lot. That's why I made this as a tip. Although I wrote a letter, I directed the that before the deadline, but unfortunately, before that the matter was over, I wanted to face it. Why I wasn't, I received the message after the presentation, which is asking me that so good. All because I want to be for this one, not that one. I don't, and then from the group of things, it depends on how I'm committed to this business. On two brand, my lord.
Please, we can't go on with this. Now, this matter is adjourned to the 5th day of May, 2026 for continuation of hearing. Yes, Counsel, this is not the end of this case. So you may one day truncate the hearing of the case in one day and the court will still do something. But the claimant is awarded a cost of 50,000 naira. You can put some fuel in your car. Can put some fuel in your car. Would that be all? What is my own law?